Yes, made on public property or
Public
whatever.
it's not a public
There is
statement.
no quarrel to that, my lord.
All right.
It would be a judgment in them, there is no quarrel to the legal position, my lord. But here it's not on a public street. There are two adjoining
No,
plots.
the SDM says that the SDM says there is encroachment.
Not, it's a private road. It's a private encroachment. इनके हमने अगर जमीन पे 1 फुट दबा लिया या 2 फुट दबा
And
दिया है,
even the corporation says it's
Yes,
encroachment.
mission is not on the individual rights is affected. Well, here the petitioner's individual rights are affected, easementary rights are affected. There is no public nuisance at all. So individual rights would not be adjudicated in a writ petition. But there is a lot to be said on the other side. If we file a detailed reply, not your lordship will relegate us to for the filing of a
No,
civil.
the SDM says as regards easementary rights are concerned, you can go to the civil court.
That is the dispute.
But he says that there is encroachment.
No, there encroachment of private land. There is no encroachment of the public land.
It's a street.
Let us assume, my lord, that is a encroachment. Let us assume. But the encroachment of the private land, that there would not be subject matter of adjudication here, my lord. It's only a right of, it's a right of.
What about illegal constructions totally, which are not permissible, no records, nothing, no ownership, no permissions, construction?
Have you challenged this order of the SDM?
But they have challenged in this petition. my lord.
No, there are findings against you in that order of the SDM.
Ultimately, eventually the application was dismissed.
Once you don't challenge it, it becomes binding on you.
Not we will also challenge it. But since the
No,
application
that
was,
may happen in the future, but
eventually this was dismissed, my lord. So it is a subject matter of revision before the London session judge. Not we have not filed any.
no, that we have
appeals.
heard. That objection we have heard.
Yes, my lord. So not my submission is not.
But it is not
Pure and
totally.
simple question of easementary rights, my lord. Pure and simple private rights of two individuals, my lord.
It is this actually this cause here raised here does not seem to be very diverse of
Blood,
the directions
they'll reply then.
in the PIL.
Blood, it's that means
That is not
public
applicable.
Streets. Here, it's not a public street, my lord.
No, somebody has to decide that. That is why collector.
Find a detailed, find a map also because I have seen it. There is no encroachment on the public street. It's not a question of public street.
That
my
is
lord.
why the collector was there.
He is living adjoining to this temple, my lord. It's an old temple, 100 years old. It was inaugurated by Shankaracharya, my lord. I placed all those photographs. He is adjoining to the living, adjoining to the temple. Now what he has done is, my lord, his access is from the main road. That is not in dispute. Now he's opened a side gate towards the temple and he says it's an encroachment. That road is being used from time immemorial. I'll find a detailed map, the location of the petitioner's house and the temple also, and the necessary documents also. I'll find documents on detailed reply to the petition. Because I have got the map prepared. If a lordship can see all that petition, I'll place all that material before a
So
lordship.
why are the authorities silent?
Authorities are in hunky-dory, my lord. They are hand in glove with the Samiti.
Yes, Mr. Parashar.
And Samiti has political preference, that's why authorities decide.
Submission is, I'll file a detailed reply, your lordship may examine it. Who is at fault?
Fine, but let us ask from the authorities that once the SDM says that there is encroachment, what do you do thereafter?
But the encroachment, may I submit, my lords? On behalf of the state, I am making submission, my lords.
No, is there any stay in this petition?
No.
Then what holds you?
Lords,
What holds you?
May I submit, lords? Lords, my respectful submission is this, that this is the dispute solely between two parties in respect of their own lands, that who has encroached on whose land. Now, this dispute has to be taken, this question has to be decided by by the court below, wherein, my lords, I have already submitted that.
Your officer,
This is a disputed.
your officer says in that order that on Sarvajanik street पे
नहीं,
encroachment.
सार्वजनिक नहीं सर, सार्वजनिक नहीं है,
आप पढ़ लीजिए
सार्वजनिक नहीं है। ये सर मैं लास्ट पैराग्राफ पढ़ता हूँ जो मैंने फिर से पढ़ा था, पेज नंबर 64
फाइंडिंग्स पढ़ लीजिए उसकी।
फाइंडिंग्स ये जो लास्ट में आया सर वो देख लेते हैं। प्रकरण का अवलोकन किया, अवलोकन से स्पष्ट है कि आवेदक द्वारा मकान पर जाने के रास्ते पर अनावेदक द्वारा अतिक्रमण के संबंध में प्रकरण दर्ज किया गया है।
Come to third para of page number 62 and fourth para of page number 63.
Page 62.
62
Third para of page 62.
प्रकरण में अग्रेतर कार्रवाई करते हुए
यहाँ से आ रहा
हाँ
है
सर।
प्रकरण के
प्रकरण में अगेतर कार्रवाई करते हुए संलग्न दस्तावेजों।
4 लाइन छोड़ दीजिए, यहाँ से आइए
हाँ,
प्रकरण के आद्योपरांत।
हाँ, प्रकरण के आद्योपन जो स्थिति उभर कर सामने आई है वह यह है कि प्रकरण में पार्टी नंबर 1 एवं अन्य रहवासियों द्वारा उपयोग में लाए जाने वाले सार्वजनिक मार्ग को पार्टी नंबर 2 द्वारा अवैध चबूतरा एवं लैट्रिन बाथरूम बनाकर एवं पानी का पाइप का पोल लगाकर उसमें एलईडी लाइट लगाई गई एवं इसी क्रम में चबूतरे को घेर कर उस पर टीन का स्थायी शेड लगा लिया गया है, जिससे आवागमन हेतु प्रयोग में लाई जा रही कंजर्वेंसी को अवरुद्ध कर दिया गया है। उक्त मार्ग आवेदक पार्टी नंबर 1 के घर पहुंचने हेतु एक मार्ग है एवं कंजर्वेंसी पर अवैध निर्माण किए जाने से अन्य रहवासियों को पानी निकासी अवरुद्ध हो गई है। मंदिर की दीवार आवेदक की दीवार से सटकर नवीन बनाई गई है।
अब पेज नंबर 63 फोर्थ पैरा।
सर
मंदिर निर्माण से स्वीकृत दस्तावेज एवं जमीनों से संबंधित दस्तावेज।
मंदिर से स्वीकृत दस्तावेज। हाँ सर, मंदिर से स्वीकृत दस्तावेज एवं जमीन से संबंधित दस्तावेज प्राप्त किए जाने एवं मंदिर प्रांगण के अंदर कार्य वैध है या अवैध है, उक्त दस्तावेजों के संबंध में उभय पक्षकारों को दिनांक 6/9/17 को मंदिर निर्माण से संबंधित दस्तावेजों को जैसे भूमि किसी समिति या ट्रस्ट की है, भूमि में निर्मित मंदिर की अनुमति किस संस्था से ली गई है, नगर निगम नजूल लाइट लगाने संबंधित दस्तावेजों विद्युत विभाग से अनुमति ली है या नहीं, पेश करने के निर्देश दिए गए, जो समक्ष न्यायालय के में उभय पक्षकारों ट्रस्ट द्वारा आज दिनांक तक प्रस्तुत नहीं किए गए।
It's a 100-year-old temple. From where we'll bring the documents of titling. 100-year-old temple.
Electric pole which has
Sir,
taken
so far
inside the
that
premises
yes,
still
has
there.
been
Will
not be
erected
trying to see
back.
P9 में भी
The electric pole is still there. It has not been removed at all.
No,
ये है ना।
it is also 100 years back.
Not electric pole. ज्यादा ऐसा temple का सवाल है. I place all those documents on record.
The
100 years of
photographs-
documents, not I bring it on record.
Photographs are
I did
clearly
it,
showing that electric
Block,
pole is
this
taken
temple
under
was
inside the
inaugurated by a
premises.
Shankarachaar block. I placed all those documents, elaborate photographs and the documents on record.
But we'll kindly see this P9 for a moment.
Who has to take action?
But P9 में भी seen for a moment.
Who has to take action? You or the corporation?
But it is the SDM somehow, in case if we found that this is on a public street, but in case if there are documents and there is a fact malord which shows that this is a dispute between two parties, then that has to be decided malord.
No,
He is not the authority malord to decide this
conducts
question.
an inquiry.
Pure question of civil nature.
he
malord.
conducts an inquiry and finds that there is some public property is being encroached upon.
नहीं, ये अपने डॉक्यूमेंट लेके नहीं आया, ऐसा आया सर उसको।
Who has encroached upon, that's not the concern, but what are the authorities
No,
doing?
but whether malord
That we would like to know.
The question before the SDM was malord whether that is a public way or that is not a public way, that is somebody's private land malord. This is the question malord. Since they did not
Let
produce
us-
and the proceedings were under section 133 of CRPC.
Let us ignore the SDM order. The earlier order, the single bench, said that the collector had to decide, had to take a decision.
Malords?
Where is that decision of the collector? Let us ignore the SDM order.
Yes. So malord, this is the
So the
collector.
collector obviously has to decide based on the directions passed in that PIL.
That is malord, admittedly the position is malord that the matter was relegated to the yes malord, delegated to the SDM malord for deciding it. Malord. So he has taken the decision and that order is before your lordships malord. The challenge in the present petition.
Then you tell us what action will you propose?
And we'll file the reply to this, malord. I'll just call for the record, malord. Let malord, whether they have produced any documents or something, malord, I'll file the reply. Malord, grant me some time, malord. We'll file the detailed reply.
You are for?
Malord, I'm for a state, malord.
State means
Malord, respondent authorities, malord.
collector SDO.
Collector and SDM.
Yes, malord. Respond number
No, you
3 and 4,
file
malord.
reply yet.
Malord,
You can't file reply.
They have not filed a reply.
we have not filed the reply. The corporation has filed the reply. 1 and 2 has filed, malord. We have to file the reply.
So then the corporation has to explain why they're sitting quietly.
Corporation, if my lord, the permission, building permission is not there, then that action can be taken by the corporation. But my lord, so far as the encroachment on public land, if at all,
SDM says.
that would be in the jurisdiction.
SDM says in the final paragraph, the building permission is not there, you are free to go ahead.
Well-
What did you do thereafter?
No, the matter was sub judice, my lord, therefore no
There is
action.
no stay.
My lord, I bow down to my lords, my lord, but if my lords may pass any order, my lord, we are bound by it.
Find over detailed reply. Within 2 weeks.
Only concern is, my lord, because the matter is sub judice, and if any action is taken, my lord, then that would create another litigation. Lord, that is the only reason that no action was taken, looking to the fact that the dispute is of the nature of easementary rights between two parties. If my lord's direct, my lord, we would take any appropriate action as per in accordance with law.
No, why do you want to? Why do you want?
My lord, it's only to avoid multiplicity of litigation. My lord,
Why do
that's
you
all.
want the gun to be placed on our
My
shoulders?
lord, it's only to avoid
You would like to
multiplicity
know
of
that
my
in
lord.
these circumstances, what action do you propose?
My lord.
Why do you look up to the courts always
My lord.
and pass on the buck to the courts?
That is not the intention, my lord. The
In these
only
matters, it normally happens. You pass on the buck to the court, let the court decide, then we'll
My
see.
lord.
So that we are not to blame.
The problem in this case is, my lord, is because there are disputed questions of facts as to the ownership and title of.
Let the collector say so.
Yes, my lord.
Your SDM says against you. Yeah, SDM says it's an encroachment on the public land.
That is the only difficulty. If during the pendency, if we take any action, then that would give rise to another litigation, my lord. तो वही तो बोल रहा है सर कुछ तो लगाना पड़ेगा डाइट
ये आपका नगर निगम के अधिकारी के स्पॉट इंस्पेक्शन रिपोर्ट देखिए.
मतलब that record is not with me, मतलब I'll call for that record.
No, it is there on the SDM's order, 63 page.
ये देखिए
वो आप ही की रिपोर्ट है कि ये कॉन्स्टिट्यूएंसी है,
मतलब by difficulty I am not in possession of that spot.
निर्माण भी नया प्रतीक हो रहा है, 100 साल पुराना मंदिर है, निर्माण नया प्रतीक हो रहा है, ये फाइट नहीं है.
Temple main.
आपका ऑफिसर ही बोल रहा है अभी.
हाँ.
What else remains now?
Current situation, मतलब we'll file a status report.
आपका डायरेक्शन था, हम लोगों ने फोटो, आपको भी डायरेक्शन था, स्टेट को भी फाइल करेंगे फोटो म्युनिसिपल कॉर्पोरेशन, कुछ नहीं, इन्होंने स्टेटस रिपोर्ट फाइल.
Order of
It's quite two orders.
Current status report file.
We have taken time to file.
Why current status report when
The last-
order of
the last-
SDM is final and binding?
Yeah, that's it. The encroachment has to go.
The last order sheet was.
If you had any grievance, you could have challenged the order of the SDM. You did not do so. Alright, इसमें लिखिए that this petition has been filed praying for the following relief. Or next para. At the very outset, there is counsel for the respondent number 5, Shri Agrawal, raises a preliminary objection as to maintainability of this petition by contending that the impugned order of the SDM dated so and so passed, that is
P12.
P12. Can be assailed in a revision before the sessions judge under the CRPC. Under CRPC. Full stop. It is contended that the said remedy has not been availed and therefore this petition is not maintainable. Next para. Per contra, learned counsel for the petitioner submits by referring to an order passed in rem in a PIL dated so and so in extra.
I'll just point. This is 19/7/2013, page 70. P15.
70.
170.
19/7/13 in WP 2214 of 2005 P15 that in respect of all unauthorized religious constructions made on public property, the court had the coordinate bench of this court, while disposing of the said PIL, had passed the following directions. So, court. page 71 and 72.
वाले मंच में लिंक ना हो जाए
Next paragraph. The learned senior counsel Sri Sharma also refers to the order of a single bench passed on 13/9/17, WP 13734 of 17, filed by the present petitioner herein, raising the same cause as raised herein. ये SDM का order हो गया था तब तक?
नहीं नहीं, उसके बाद रिप्रेजेंटेशन दिया और हमारे रिप्रेजेंटेशन को 133 ट्रीट करके एसडीएम क्या भेज दिया?
Raising the same cause as raised herein, prior to the passing of the impugned order of SDM. The said petition was disposed of in the following terms. So quote कर देना, page 45. First off, it is submitted that pursuant thereto, annexure P8,
Yes,
a
ma'am.
representation was made to the collector,
कलेक्टर
so as to enable the said authority to decide in terms of the order of the learned single judge. It is also submitted that instead of the collector deciding the matter, the case was taken up by the SDM under section 133
सीआरपी से
CRPC, where the impugned order P12 dated so and so was passed. Which is subject matter of challenge herein. Next para. Before proceeding ahead, it would be appropriate to extract some of the findings rendered by the SDM in the impugned order, which are as follows. Before to push lena. Next para. From the aforesaid findings rendered by the SDM in the order dated 28/4/18, which is not assailed by any of the respondents, what comes out loud and clear is that the SDM found on the report submitted not only by the revenue authorities but also based on the report submitted by the zonal officer.
म्युनिसिपल अथॉरिटीज
One Shri Dinesh Pratap Singh, the officer of the Municipal Corporation, Jabalpur, that the construction alleged to be unlawful by the petitioner was made on conservancy. And the construction appears to be legal. Next paragraph. The SDM in the impugned order finally that if the corporation finds that the construction is illegal, then it is free to remove the same. The SDM also afforded opportunity to the petitioner to raise the cause of breach of easementary rights, if any. Next paragraph. Petitioner is here before this court primarily contending that that once it was found that the construction in question was unlawful and over the public property and blocking the passage, then it was incumbent upon the collector to have decided the same in terms of the order passed by the single bench. It is submitted that the authorities has maintained a sphinx-like silence. Full stop. Referring to the reply filed by the Municipal Corporation Respondent 1 and 2. It is also pointed out that the Municipal Corporation admits the fact that there was unlawful construction. And the construction in question was unauthorized. but does not disclose as to what action was taken pursuant thereto. Next para. What is surprising to notice that the state has chosen to remain silent in these last 4 years by not even filing a reply. Full stop. State Council, however, seeks further time. File reply. Next para. The State Council is permitted to file reply, but the Council for the Corporation is directed to file an affidavit of the Municipal Corporation Commissioner
My lord.
as to what action, consequential action is proposed
My lord.
in terms of the contents of the reply and the findings, the unchallenged findings of the SDM
My lord.
in the impugned order, so on so. Let the same be done within 2 weeks.
2 weeks.
List in the week commencing 23rd January.
My lord.
In the meantime, I'll also file my.
Please. Just file me. Chitte आप लिखा है ना. लक्ष्मी को बोलो. क्या फर्दर एक्शन ले सकते हैं अभी देखना पड़ेगा. लोग लगा देंगे इस ऑर्डर को चलेंगे. इस ऑर्डर को चैलेंज कर.
Single bench order is dated. Single bench order is dated.
भले.
13/9/2017.
39/17.
Yes.
No pending है.
We submitted our application on 20th/9. Impugned order is 28/4/2018.
जोड़ देंगे इसको फॉरवर्ड किया. उसमें लिख देना the municipal corporation in their reply have also stated that consequential action could not be taken because of the pendency of this petition. Now we ask you to
My lord.
propose what action.
Propose, my lord.
Sorry.
Public.
Serial number 35, C. J.B. Singh, Deepak Panjwani.
Right. क्या हुआ? 33.
33.
34 dropped it.
34 drop.
Yes.
My lord, on the last date of hearing, this honorable court had ordered the respondent to file a regent order on rejecting the claim. They have today filing the order, so I may be permitted 4 weeks time to file the submission. My submission.
You have filed it.
Yes, my lord.
Today is that filing.
Today you have
itself.
filed it. Yes. इसमें लिखिए in compliance of the order passed on 4/11/22, the respondent number
My lord, 1.
1 has passed an order dated
27 para.
27/12,
Yes, my lord.
which has been filed but which is not on record.
My lord, it has been filed today itself.
Has been filed today
Yes, my lord.
and therefore the same has not come up. Registry to verify and place it on record. Next para. The petitioner is free to file a response to the said order. List after 2 weeks.
4 weeks time.
After 4 weeks, as prayed for.
Highly obliged.
नाम बताएं.
Karthik Jaggi.
कार्तिक
Jaggi.
Council adjusted. Anuj Agrawal.
Serial number 36, C. Anuj Agrawal.
Though I was adjusted, Malad, but my program was cancelled, so I'm here, Malad. I'm ready to argue. That's
Okay.
Malad. So the matter pertains to an order passed under section 28 of the VAT Act, Malad. Malad, the pleadings are complete, Malad. I'll take 10 minutes to argue the matter, Malad. Malad, the order impugned is annexure P5, page
by?
Malad, the commercial tax officer, Malad.
You are challenging which order? P6.
Malad, P5, basically, Malad, it was the
P5
order
is page?
page 83, Malad.
83. Good. Yes, are you appearing?
Yes, my lord, I am for R3. Former party reply has been.
No, what about the state?
We have also filed reply. Associate is my lord. Actually,
State has filed reply, yes. State has filed
my
reply.
associate has.
What about the bank? Bank has filed.
Malad, the bank is formal party. They have filed the reply, Malad, because there is nothing against the bank, Malad. Basically, Malad, the order, the impugned order has been passed, directing the bank to freeze the account of the petitioner company, Malad, on account of certain tax dues due to some other company. Under 28 Malad, the VAT Act, there's a power for special recovery of Malad, that if some amount is due.
This is not appealable.
Malad, this is not appealable. Admittedly, this is not appealable because the tax dues are not against the present petitioner company, Malad.
Yes, are you ready?
Yes, sir.
This is not appealable.
This is not, Your Lordship?
Is it appealable or not? This order.
Order impugned.
I just joined.
Court is asking whether the order impugned is appealable order or not. Malad, it is not, Malad. Section 46 of the VAT Act may be seen, Malad. The appeal is provided under section 46.
28 is special mode of recovery.
Malad.
46
is the appeal.
So where is this 28 excluded?
Malod, this is not excluded, Malod. If Malod may permit me to read 46, it says, Malod, any dealer or person aggrieved by an order of assessment or reassessment under section 20 with or without penalty, or
No,
by
an
an order
order.
of reassessment under
After order, this term,
Malod,
this term assessment is not there in the book. It says only order. Any dealer or person aggrieved by an order passed under this act.
Malod, probably mine is the old book, Malod. Malod, but if Malod would see, 28 does not, is not, we are not against the assessment.
Any order, it says any order. Does not specify what kind of order.
Malod.
It was amended in 2006.
Mine is.
Your book is prior to.
Malod, I'm referring to the law times, Malod, maybe because of that. The 2000. Malod, I'll.
Provided it is passed by any authority under 31 C2F. 31 C2F. What are those authorities? 31 C2F. Who has passed the order?
Malod, the order has been passed by the commercial tax officer, Malod. Commercial tax officer.
Deputy Commissioner, Additional Commissioner.
So 31E includes commercial tax officer. Go and appeal.
Malod, I'll examine it. Malod, may keep it tomorrow, Malod. I'll examine.
Not tomorrow, we'll pass it over. Pass over, sir.
Malod, because in my humble submission, Malod, the order is covered by order of a coordinate bench, Malod. Directly covered, Malod. Recently, Malod, not recently, Malod, the order I'm relying is of 2017, Malod.
No, that's fine, but why can't you
Malod, in that case also, Malod,
you please present that citation before the appellate authority.
Malod, in that case also, the order has the Malods have relegated the matter before the taxing officer, Malods. With an Malods, kindly permit me to read this order, Malods. It's a very short order, Malods.
Which order?
Malods. Malod, the facts are Malod, that Malod, para 3, the petitioner has filed this petition being aggrieved by the intimation sent by the respondent bank to the petitioner regarding attachment of the petitioner's bank account on account of notices issued by the authorities under section 28(1) of the MP VAT Act. Malod. Learned Senior Counsel for the petitioner submits that the petitioner has left the firm so-and-so, District Chandwala, on 2002 and a fresh partnership deed excluding the petitioner was drawn up on 1/2/2002. It is submitted by the Learned Senior Counsel that though the firm continued under the same name, however, the petitioner had nothing to do with since 2002. It is submitted that subsequently the firm got itself converted into a company in 2002 and got itself registered in the name style so-and-so. It is submitted that the aforesaid company was subjected to assessment for the period 1/4/2002 to 31/3/2003 and was assessed through tax by the concerned authority. It is submitted that it appears that the company did not pay its dues, as a result of which the authorities, without taking note of the fact that the petitioner had nothing to do with the said company, has issued a notice under section 28(1) of the VAT tax, pursuant to which the bank authorities have attached his account. Learned Senior Counsel submitted that the aforesaid action has been taken by the authorities without giving an opportunity of hearing to the petitioner, without serving the petitioner with any notice, or without considering the aforesaid aspect, and in such circumstances, the impugned orders of the intimation by the bank be quashed and the petitioner's account be released. Learned Government Advocate appearing for the state submits that the petitioner has approached this court without filing any reply or representation before the authority concerned, who have yet to apply their mind to the issues raised by the petitioner, and in such circumstances, the petition filed by the petitioner being premature deserves to be dismissed. We have heard learned counsel for the parties at length. From the perusal of the record, it is apparent that the issues raised by the petitioner before the court have not been placed by him or raised by him before the authorities under the Act. It also appears from the notices annexed by the petitioner along with the petition on pages 17 and 18, which are the notices and the orders issued under section 28 of the Act that have been issued to the HDFC Bank and have not been issued to the petitioner. It is therefore apparent that as the issues raised by the petitioner have not been placed before the authorities, there is no application of mind by them in that regard. In these circumstances, the petitioner is disposed of with a direction to the effect that the petitioner shall file a representation reply before the commercial authorities under MP VAT Act within 3 days, along with a copy of this order passed today and a copy of the petition. And in case the petition does so, the authority concerned shall thereafter examine the contention of the petitioner, consider the same, and pass the reasoned order taken. So and so. It is further directed till such exercise is completed that the authorities, the bank petitioner's account shall not be attached, nor any shall further recovery be made therefrom.
Your Lordship, may I submit something? Your Lordship, the assessment period for this particular order is 2002, 2003, Your Lordship. The amendment came in 2006, Your Lordship, of the order or the assessment order, Your Lordship. So one is that point, and second, the issue is, Your Lordship, that the question of alternate remedy was never a question in this order, Your Lordship.
Well, it's here in
That amended provision would not apply.
it will apply. So my humble submission,
how will it apply to that case which you are citing?
Because in that case also, I have also got the impugned notice of that case, which was, but the commercial tax department has issued to the bank. Here also the commercial tax department has issued to the bank, and the bank has in turn written the notice, given a notice to the petitioner that your account has been sealed in terms of the order of tax. In that case which Malods have just read, there also the order impugned was passed in, the notice was given in 2017. In the present case, the notice was given in 2021. I have also got
this is pertaining to which assessment year? Your case.
The assessment year, because it is not the assessment of the petitioner's company, of the respondent's company, the assessment year, as mentioned in the impugned order, it is not given in the impugned order, because the assessment is not for the petitioner company.
So what is your case?
My case is that there's some tax dues against one of the companies. The under section 28 of the VAT Act, the commercial tax department has seized the account of the petitioner company. That is a different entity. In alleging that certain amount has been, we are in possession of certain amount, which we are supposed to give to the respondent company, to the other company against which the assessment is to be made. So you
are the debtor of that company.
We are
under scrutiny.
Under scrutiny,
You are the debtor of that company.
That is the allegation.
So that provision is there under 28.
That is there.
That can be done.
It can be done, We are not in dispute, So what my humble submission is, firstly, there is no finding that whether we have to give some amount to the company under scrutiny. We have not been asked anything. Directly a notice was issued, an order has been issued to the bank, The bank attaches our account. We are a public limited company, We are not a private limited company,
Directors in both, Your Lordship.
Also P5.
Your Lordship, the directors of both the companies are same, Your Lordship.
And this is the direction to the bank, I think. वो तो pending होगी against that person, वो जो है दूसरी कंपनी में. Case में 28 does not provide for any remedy for you. Section 28 that the taxing authority can issue you a certificate or recover from you after hearing you. Is it there or not in the amended provision? 28. It must be there. I mean, normally it is there. Such provisions are always there. This is under 28, which subsection?
Malots 28(1), Malots.
1.
Let's see. Subsection 5 empowers.
So this notice was addressed to you.
Malod, the notice was not addressed to me. It was addressed directly to the bank, Malods, where my account is there. Directing them to Malods to seal the account. Malods? P4, Malods? Malods, it's a company, Malods. It's in the name of the company. It's a public limited company, Malods.
You need 28.5.
Malods, 28(5) provides for
The mechanism is there.
Malod, but
for
the
hearing
notice
you.
was never issued to me, Malods. Malods, kindly see the impugned notice, Malods. That is at page number.
So then what is the apprehension?
Malods? Because in
So you
person.
make an application and say that I should be heard.
Malods, that is what
The
the.
inquiry which is under 28.5
Malods.
will be conducted by the.
Malods, but in pursuant to that order, Malods, in page number 84, the bank has freezed my account, Malods, and has also recovered. Malods, kindly appreciate page number 93. Immediately thereafter, the amount which was lying with the account of the petitioner, the amount was transferred in the account of the commercial tax department.
So this kind of notice must have been issued to you also. Fine, please find out and tell us.
Lordship.
Under 28.1
Your
A,
Lordship.
B, there is you can recover from him as well as from the bank.
Yes, Your Lordship.
From his account.
Corporate wheel can be lifted, Lordship.
You are not the dealer.
I'm not the dealer, Malods.
Your Lordship.
You are not a director there.
Malod, this is by a petitioner. The petition is by a company wherein, Malods, there are a number of directors. Amongst those, Malods, two of the directors are common, Malods. I have pleaded this. I have not, Malods, shying away with that, Malods. But that company is a private limited company. The direct responsibility of the directors are different. Here, Malods, the company is a public limited company, Malods. A listed company. Anyone from public can acquire the stocks of this company, Malods, of the petitioner company.
You are a common director and
Only two persons are common directors, my lords. But
you are not that one.
my lords, I am the company, my lords. This is by a company.
Your Lordship, para 5 of our reply may kindly be seen, Your Lordship.
You file reply.
Your Lordship. There's a
commonality है दोनों में.
Sir, but my lords may kindly appreciate.
Now, what do you have to say about this amended 46?
My lords, that is there, my lords. I could not lay my hands earlier, my lords. My lords may relegate it, my lords.
You can challenge it before the appellate authority. The learned counsel for the petitioner does not dispute that the impugned order dated so and so, passed by so and so. Impugned order passed under section 28(1) of the MP VAT Act by so and so, on so and so, is appealable under section 46. Amended section 46 of the VAT Act. ये कब का order है?
My lords, the order impugned is
P5 is dated.
My lords, P5 is dated, my lords.
There's no date.
There's no date, my lords.
P5 is 24/9. You have said 21. 24/9/21.
My lords.
Next part. Accordingly, this court declines interference and relegates the petitioner to avail the remedy of appeal under section 46 in accordance with law. Dismissed with the aforesaid liberty. Disposed of with the aforesaid liberty.
नाम बताएं मैडम.
सुलेखा शर्मा
और
for R3.
You are for?
R3. Bank.
For the bank.
State Bank.
Yes.
I'm grateful, my lords.
Yes.
शेयर नंबर 37 से ग्रीष्म जैन, दिलीप परिहार, आशीष कुमार नेमा.
Lord, I make a small prayer, my Lord. This, due to some personal difficulty, my Lord, this may be taken only next week, my Lord. Is this a matter which has to be heard finally? I am challenging the order of the Great Court.
So what happened in the SLP?
SLP सर वही next week आ रही है या अभी उसका डेट तो नहीं आई लेकिन लास्ट में लगी थी. आपने ऑर्डर किया था 2/11/22 को 12/12 के लिए 12/12 के लिए लगी थी before the registrar and it was adjourned.
Subject to order passed in SLP, will dispose it of. Why should we keep it pending?
The SLP, if
it is pending since
my Lord, that is why the last date, my Lord, I argued before this court, my Lord, that I'll distinguish the case which has been relied by, which is in the SLP. That's a different set of facts, my Lord, and this is a different set of facts.
No, are you the prosecuting agency?
I'm the employer.
You're the employer.
I'm employer. I'm employer, it's a matter of date of birth.
And there the challenge was by the prosecuting agency, which was dismissed by the coordinate bench.
No. Same thing. Date of birth, it is related to date of birth. This matter pertains to date of birth, my Lord. Here, my Lord, this judgment has been relied in another WP, and in that WP, we lost it. Against that, we filed the writ appeal. Our writ appeal was dismissed. So we had gone to apex court, my Lord. Notices were issued in the apex court. And then, my Lord, matter was fixed for.
So how long do we wait?
That is why, my Lord, the last date of hearing, my Lord has said that I said that I'll distinguish and I'll argue the matter. For that, my Lord, I'm making it, it may be, if possible, my Lord, may be taken next week, my Lord, or day after tomorrow.
Next week.
Because I've got some, because I could not properly.
All right. Yes, Mr. Gildial, any objection?
Maharaj, we keep it in the next week.
All right. The learned counsel, Shri Grish Jain, for the petitioner, is not prepared with arguments on admission and therefore seeks a short adjournment next week.
My lords, I'm appearing for respond number 2. The board.
2. All right. Next week.
नाम बताएं.
Akash Lalwani.
Condonation of delay, what is that?
That, my lord, there is a delay in appeal, but the registry says there is no delay.
Acha, acha. IAS only
Formal
condonation of delay is taken up, considered and dismissed as inflectuous since there is no delay.
As registry point out, my lord.
Oh. Shall dispose of.
Chair number 38, C. Arvind Singh, James Anthony.
Lordship, this is matter relating to compassionate appointment. Lordship, the petitioner has challenged.
Somebody is adjusted.
Lordship,
Respondent is adjusted. Mr. James Anthony is adjusted.
it may be Lordship any fixed date may be given.
क्या matter है?
This is relating to compassionate appointment. Lordship, the petitioner has challenged the order of the Center Administrative Tribunal. Lordship.
The counsel for the respondent employer is adjusted. List after the period of adjustment.
Lordship, any fixed.
Yeah.
Chair number 39 with connected matters, C. Satyam Agrawal, Tanvi Khare.
Yes.
My lord, in this case, the prosecuting agency have filed the SLP before Honorable Supreme Court. My lord, we have been given the diary number also. This matter relates to challenging the rejection of sanction, my lord.
You are the prosecuting agency.
Yes, your lordship.
Right. So we'll dispose it off. You can revive the WP whenever the SLP order is passed in your favor. You can revive the WP by filing an IA.
My lord,
that is possible these days under the amended rules.
My lord.
How long do we keep waiting?
My lord, that's there. Because here, my lord, what has happened, because on merits also, my lord, the order, I am able, if my lord permit, I may demonstrate that that the judgment will not be applicable to the facts of the present case, my lord. On the merits also, I can address, my lord, on that.
No, the prosecuting agency cannot challenge an order of
an order rejecting sanction.
Rejecting sanction. That is exactly the point that was decided.
My lord.
Rightly or wrongly, that the Supreme Court will decide.
My lord, but if I am able to demonstrate from the judgment itself, which has been relied upon by the coordinate bench, my lord, that judgment was wrongly applied to the facts of the case. In fact, that judgment itself permits the prosecuting agency to challenge the rejection. So then, in that scenario, my lord, the judgment will not have any binding value. My lord.
उसमें आपने review नहीं लगाया?
My lord, that review has not been filed. They have directly filed an SLP in the matter. But
same prosecuting agency here.
Yes, my lord. Because although in batch of the cases there is EOW and I think CBI also is there, but so far as these batch of cases concerned, some of them are relating to the same investigating agency. The same judgment, my lord, the judgment Bhati judgment has been relied upon, my lord. In that itself, my lord, in paragraph number 6, the prosecuting agencies has been directed to prefer to challenge it by filing a petition before the superior court. That has been mentioned there, my lord.
In which case?
In the same case, my lord, that is State of Punjab versus Mohammad Iqbal Bhati, my lord. 2009-17 SCC 92. I have the copy of it, my lord. I'm just sending. Apart from it, my lord, in 2011, there is another judgment of the coordinate bench in which it was observed that that such orders have to be challenged by filing WP. These orders rejecting sanction can be challenged by filing WP before the.
So you did not show these orders.
These judgments were not pointed out. Bench. That judgment was not pointed out, my lord, before the court. And
where is that?
Yes, ma'am.
Finding.
In this, my lord, paragraph number 6 is important. This is exactly the judgment which has been relied upon by the court in that judgment, my lord. Here it has been mentioned although the state in the matter of grant or refusal to grant sanction exercise statutory jurisdiction, the same, however, would not mean that power once exercised cannot be exercised once again. For exercising its jurisdiction at subsequent stage, express power of review in the state may not be necessary, as even such power is administrative in character. It is, however, beyond any cavil that while passing an order for grant of sanction, serious application of mind on the part of authority concerned is imperative. The legality or validity of the order granting sanction would be subject to review by criminal courts. An order refusing to grant sanction may attract judicial review by the superior courts. So paragraph number 6 itself indicate that, my lord. Apart from it, my lord, there is another judgment that is State of Himachal Pradesh versus Nishan Seri, my lord, 2010-14 SCC 527. In this, my lord, the Honorable Court, while parting with the judgment, my lord, has observed in paragraph number 15. Paragraph number 15 is important here, my lord. In this case, my lord, the paragraph number 15 may, by way of footnote, my lord, have it?
Yes.
By way of footnote, we may observe that investigating agency might have had legitimate grievance about the order dated 27/11/2007 refusing to grant sanction. And if that were so, no fresh material were necessary. It ought to have challenged the order of sanctioning authority, but was not done. The power of the sanctioning authority being not of continuing character could not have been exercised only once in the same material. Now, here, my lord, what has happened, the Honorable Supreme Court said that if...
When is that SLP coming up?
My lord, that SLP would come up in the second week, my lord, because presently it was presented on 16th of December.
Second week of?
Of this month, my lord, second week of this
month. It is informed by the counsel for the prosecution that the SLP arising out of the dismissal of WP 13776 of 22, State of MP versus Sandeep Kumar Lohani.
Yes, ma'am.
And others is likely to come up for hearing in the second week of January before the Apex Court. Accordingly, list in the last week of January.
Obligation.
स्लिप में नाम लिख के दे दीजिए.
With all bunch.
Serial number 40.
My lord, in item number 40, my lords, I'm praying some as a last indulgence, my lord, to comply with the order dated 13/10/2022, my lord. Looking to the reply filed by the state, my lords have directed us to file a status report on 13/10/2022, my lord. Because we had already initiated the proceedings under 248.
The fate of 248 proceedings.
Yes, my lord, that was called.
Last opportunity.
My lords, last opportunity.
Yes, any objection?
I am appearing for petitioner. And
No,
something
any objection to the request?
My lord, I have no objection.
All right. As a measure of second last indulgence, the state is granted 2 weeks or 3 weeks?
3 weeks, my lord.
3 weeks to comply with the order 13/10/22. List after 3 weeks.
Fixed statement kindly be given.
It will come up.
So I am from R7 or 8, Lordship.
You are for?
R7 or my presence remark.
Respondent 7. All right.
Pass over matter. Serial number 1, C. Praveen Kumar Pandey.
This application has been filed only for the jail custody of the appellant, my lord. As the appellant is jail since last about 9 years, my lord. As
9 years.
My lord.
Good.
In view of the Honorable Supreme Court, my lord, in the case of Sudan Singh, my lord.
No, that is 10 years.
My lord.
That is 10 years.
No, my lord. 8
The-
years. 8 years, नहीं दिए, my lord.
8 years.
My lord.
So where is the compilation of those orders filed by the state?
We are filing a updated chart also today, Your Lordship.
Today?
Your Lordship. It's
You have filed or you are filing?
No, we have already filed one comparative chart, Your Lordship, earlier. And now today we are, Your Lordship, Justice Singh had pointed out that Dashrath Singh wala judgment. So we have incorporated that and we have prepared a chart again.
What have you filed? Compilation.
Compilation along with a comparative chart, Your Lordship.
Let it come up. The state has filed certain compilation today.
Your Lordship, we are filing it
You are
today.
filing. Council of the state submits that the state is filing a compilation of orders of the apex court on the question of right of jail inmates who have completed certain minimum period of custody to be released under section 389. Full stop. The said compilation has not come up. Registry to verify and place it on record. So day after tomorrow.
Gotcha.
Thursday को कर दीजिए. Thank you.
Serial number 29. Sri S. K. Karan, Arun Kumar Nema.
29. Tribunal. Yes.
My lord, the petitioner, my lord, is the second wife of the deceased employee. On 19/3/2019, my lord, this honorable court directed that in view of the amended rules, the children of from second wife are entitled for family pension. Thereafter, my lord, we have the case was considered and we have extended the benefit of family pension to the petition number 224.
That is the children of a second wife.
Second wife.
Now, who is for the petitioner?
Mr. S. K. Karan. On the last date also he did not appear.
Did not appear. No, do you have any order?
Or we have filed the report, the status report.
कहाँ पर है?
On IA 11/4/19/2022.
Yes. Where do you say that you have given the benefit?
In para 8 month.
There are 3 children from the second wife.
4 children. 3 daughters, my lord, the benefit was extended. So far as the son is concerned, he has not submitted the relevant documents. So his case was not considered. As soon as he submit the documents, my lord, his case will be considered. the date on which the compliance report was filed, my lord, at that time the payment was not made. But subsequently, I have received the instruction that that amount has been paid. These are the bank details, my lord. My lord.
That where is that PPO, revised PPO?
IS 7 page 20.
Yeah, IS 6 page 19.
हाँ वो तीनों के अलग अलग हैं.
So they have been given what, prospectively or from backdate?
From backdating. Roshni Rajput was paid, my lord, from 27/11/2012 to 12/12/2013.
नेम तो इसमें चंद्रशेखर लिखा है. ये क्या है?
Chandrasekhar
Deceased.
was father of.
अच्छा. नहीं, इनका नाम नहीं है, इनके जो बच्चों का नाम.
बच्चों का नाम है ना वाला.
कहाँ है? उसमें PPO एक ही लगा है.
पेज 18
दूसरा भी लगा है.
पेज 18 रोशनी राजपूत.
दीपा राजपूत,
पेज
रोशनी
20 दीपा
राजपूत,
राजपूत.
एंड दो ही हैं. दीपा राजपूत,
रोशनी राजपूत और दीपा राजपूत के थे.
रोशनी राजपूत, दो ही का है.
हाँ भाई कि उसका भी मेंशन किया है कि हो गया है.
इन बेटियों का, हाँ. और PPO दो ही का लगा है. ठीक है, इनका स्टेटमेंट रिकॉर्ड कर लेते हैं. डिस्पोज ऑफ लिखिए दैट दिस during pendency of this petition on a query made by this court on 13/10/22 as to whether in regard to the claim for family pension of children of the dependent children of the second wife of the deceased employee, late Chandrasekhar
Rajput
from the Union of India has filed IA 11419 of 22 or title application so and so, which is inter alia accompanied by PPO issued in favor of Roshni Rajput, Deepa Rajput, two of the three daughters born out of the second marriage. Most of these PPOs were issued on, ये कब का डेट है? PPO की डेट नहीं है कोई. Have been recently issued, huh?
25/5/2022.
कहाँ पर है?
ये पेज 18 में. It was informed on 20.
Have been
11/5/2022.
11/5/22. Next para, though the PPO in favor of the third daughter, that is, क्या नाम है?
Alka Rajput.
Alka Rajput is not on record, but the said IA reveals that Alka Rajput has also been benefited.
My lord, may mention PPO number, my lord.
Alka Rajput has also been benefited by issuance of PPO for family pension. There are only three children.
4 children. One son is also there, but he has not submitted the documents.
Acha. Acha. Next para. Shri Yadav Peli submits that Shubham, the fourth child, from the second marriage, has not submitted any requisite documents, and therefore PPO has not been issued against him. The other also submits that if any document is submitted by the said Shubham, then the same shall be considered an appropriate decision taken. At the earliest. Next plan. In view of the above, nothing remains in the present petition. What was under challenge?
Or the order passed by the tribunal, my lord, the tribunal has declined to grant family pension on the ground that the petitioner is second wife.
Ajay. इसमें लिखिए that though the challenge in this petition by the Union of India, the employer, is to the order of the Central Administrative Tribunal Jabalpur bench, passed on so and so and so and so, declining grant of family pension to the dependent children arising from the second marriage. But since the employer has already acceded to their request of family pension, this court declines to interfere. प्रिया भी है इसमें कोई?
नहीं, प्रिया नहीं है।
They're not.
प्रिया वो अभी
वो ऑर्डर में देखिए,
माइनर है, वो 8 साल की है।
वो जो P1 है उसमें देखिए, P1 का लास्ट पेज।
प्रिया है वो।
प्रिया का क्या होगा?
उनको भी अगर वो रेलिवेंट डॉक्यूमेंट सबमिट करेंगे तो
2013। ये 1/6 दिया आपको
जी,
1/6 शेयर दिया है।
वो 50% वॉज गिवन टू फर्स्ट वाइफ एंड 50% जो है वो डिस्ट्रीब्यूट किया है 4 बच्चों में।
One is amount deposited in the pension account that has been distributed 50-50%. And so far as pension is concerned, family pension, that has been divided into 1/6 to given 1/6 to each.
Yes, 1/6 to 4 children.
So what amount of PPO is issued in favor of these daughters?
That Marot, Roshni Rajput received rupees 40,000 to 3. With effect from 27/11/2012 to 12/12/2013. In 2013, on account of marriage,
And they are children of second wife.
मेरी 42,000 इनमें सब में बटेंगे।
वो बटेंगे
6 लोग।
इनको जो पेंशन का राइट है 1/6 सारी मेजर हो चुकी है।
वो आ जाते सामने तो और क्लैरिटी आ जाती, बट वो काउंसिल उनके आए हैं कि नहीं आए हैं?
on the last date also,
फर्स्ट राउंड में भी नहीं आया।
he accepted, Marot, they have accepted the.
नहीं, जो तीनों चारों बेटियां हैं, चारों मेजर हो गई हैं अभी। आपने पीपीओ भी रिसेंटली इशू किया है।
हाँ, वो
इस समय पर चारों मेजर हैं। तो आपने सिर्फ 2 को या 3 को इशू किया, चौथी को छोड़ा, और
नहीं,
कितना कितना
टोटल
इशू किया है?
4 बच्चे हैं, 3 डॉटर्स हैं और 1 लड़का है।
4 डॉटर्स और 1 लड़का।
नहीं, वो इसमें भी जो रोशनी का नाम नहीं है।
ये देखिए पेज नंबर 10 में देखिए। ये तीनों में है। प्रिया,
हाँ है।
रोशनी,
चार-
दीपा, अलका, प्रिया,
4 डॉटर्स हैं।
4 हैं डॉटर्स।
और 1/6 का ही पीपीओ इशू करना है आपको।
नहीं, उनकी शादी तक दे आर इंटाइटल मालूड अप टू द एज ऑफ 25 इयर्स और मैरिज।
ठीक है,
So,
ऑर्डर आपका क्लैरिटी
आप-
होनी चाहिए ना उसमें।
But they have not questioned, my lord. They have not questioned our PPO. They have not challenged it.
Liberty they retain. If they have any claim left, they can revive this. They can revive the petition.
This is second opportunity.
लास्ट टाइम भी नहीं आए थे, तो इनका ये रिकॉर्ड कर देते हैं स्टेटमेंट, उसके बाद देन उसमें लिखिए दैट, ये सब रिकॉर्ड करने के बाद लास्ट में लिखना दैट सिंस no one appears for the petitioner and the aforesaid contention of the of Shri Yadav is not countered by the petitioner. This court, instead of deciding the issue on merits, dismisses the present petition for want of prosecution, with liberty to the petitioner to revive the same in case any cause is left unadjudicated, unredressed, unadjudicated.
My lord, may I also mention that if Priya also submit document that
We should not go into all that. Let them come forward.